Hey folks, attorney Andrew Branca here for Law Self-Defense. Thank you very much. That's always appreciated. I have some great content to share with you for this Law of Self-Defense show. You know, we recently covered the trial of former Fort Worth police officer Aaron Dean, who was charged with murder after shooting dead the resident of a home that he had been dispatched to investigate for a suspected burglary. It was an awful but lawful shooting under the circumstances. Nevertheless, he was convicted not of murder, but of the lesser included charge of reckless manslaughter, an insensible conviction, an unjust conviction. And then he was sentenced by the jury to 11 years, 10 months, and 12 days of incarceration. The 10 months and 12 days, presumably because this unfortunate shooting death occurred on October 12th. Not exactly a rational basis for a sentence. In any case, as part of that, I was really astonished in a very negative way at the closing argument of the state prosecutors in that case. I thought it was a travesty of justice. And it wasn't just me who thought that the prosecution did a very poor job in terms of mischaracterizing the law and evidence to the jury. They made a lot of improper arguments during that closing. And that's the opinion, again, not just of myself, but of our good friend, attorney Steve Gosney. Steve has been on my show many times before. He spent a lot of time covering the Dean trial with me, and he has very definite thoughts on prosecutors making improper arguments at closing from his perspective of working for the public defender's office in Florida. And a lot of those very insightful thoughts have been captured in Steve's great book, Ideas and Answers in the Law, now in the second edition, and for which, by the way, I wrote the foreword. And one of the chapters in this excellent book deals with prosecutors making improper arguments on closing, or really at any time during a trial, but particularly most damaging to justice and the defendant at closing. Well, what Steve's done is he took a transcript of the state's closing argument and he goes through paragraph by paragraph, almost line by line, noting all the improper arguments made and explaining exactly what the improper nature was and why those improper arguments matter, why they should not be permitted. So this is about an hour-long video that Steve produced. I want to make clear, I did a little post-production work on his video, but all the substantive legal value in Steve's video is from Steve. So in terms of legal content, 100% credit goes to Steve. By the way, I would encourage all of you to get a copy of this book. It's really awesome. And the only place to get Steve's book is at crimelaw.net, crimelaw.net. It's a very fat book, lots of great content in here for lawyers and for people interested in genuinely understanding the law. I'll also mention, of course, that Steve's not only an attorney and the author of this book, Ideas and Answers in the Law, he's also the provost for American Law Courses, where we teach traditional American law in the traditional American way, much as it's taught at law school when Steve and I attended law school, but at a fraction of the time and cost in law school and without any of the toxic politics that pervades law schools today. Again, just traditional American law in the traditional American way. Steve just finished teaching criminal law in the fall. We'll be making those courses available on a recorded basis soon. We're starting the spring semester, the second week of January, with courses in property and evidence, much like they're taught in first-year law school, being taught by expert professors. Steve is playing a huge role in identifying and recruiting the professors for all these courses. And we have a bunch of other courses in the curriculum as well. If you sign up before the end of the year, by New Year's Eve, you can save 50%. That's over $1,000 per course for the spring semester, folks. So if you're at all interested in learning the law as if you would have been taught it had you gone to law school, this is a tremendously inexpensive, time-sensitive manner of doing that relative to law school. And you can learn more about these American law courses and saving 50% during this pre-registration period up to the end of the year by pointing your browser to AmericanLawCourses.com. That's AmericanLawCourses.com. All right, folks, with all that out of the way, here is attorney Steve Gosney.
Hello, Stephen Gosney here, and I wanted to go through the Aaron Dean trial a little more specifically. Andrew Branca, with the Law of Self-Defense website, did a pretty good legal analysis of the problems, the fundamental problems in the misunderstanding, I think, of both the defense and the state on the legal aspects of that closing. And then, of course, we also did this kind of funny dust up video with the buzzers laying with improper arguments. And it's funny, and I think those were proper objections, but I wanted to get a little more in depth about specifics, specifically why I identified those objections as objectionable, why, what the basis is. And I will say, reviewing them, some are going to be weaker than others, some are stronger than others, but the concept, I want to explain why I think that they're objectionable, fitting under the 7 criteria of objection. So let's do this a little more dispassionately, a little more in writing, a little more with an appellate flavor. Fair enough. Okay, and so first thing I want to do is we're just going to go through this all in writing. It's very legalese, but it is applying the concepts of the 7 different categories of closing argument objections to a particular closing argument. So with that, let's see here. We're going to do share. Okay, so let's take a look at this. So this is the closing argument review. Now here's the 7 rules, or the 7 categories which we see are commonly violated. Now, I don't think this is an exclusive list, and some of these are kind of a little broader, and you'll see when we talk about especially the burden shifting, about really it's minimizing a burden or misstating the burden, which you could characterize as a misstating of the law, but it's under the whole burden of proof issue that the defense needs to really keep an eye on. But these are the 7 concepts that the defense attorney should have next to them when the closing arguments are going on, so that they're ready to object to an improper closing argument. And then when you say, what's the basis for the objection, you can put it into one of these 7 categories. So here's how the prosecutor opens up in the Aaron Dean trial. If you feel safe, if you can't feel safe in his home, where do we feel safe? When do you think about your house? When you think about safety? It's where you go to retreat to get away from the world. It's where we grow up. It's where we have kids. It's where we mark on the outside of the doorway where they've gotten taller and taller. It's where we make memories. That's why it's so sacred. That's why it's so important. Okay, so this is they're painting this Norman Rockwell, or what is it, the painter of light, little image of all these childhood warmth and memories of home, right? Now, this is an appeal to sympathy and a golden rule violation. So it's a setup, and this prosecutor is very clever and very careful in the way she presents this, because it's not blatantly obvious, all right? But it's the we. If you can't feel safe in your home, you, the jury, where do we feel safe? We together. So it's making you feel safe in your home is not the issue at the trial. Okay, it's an appeal to the sympathy of the jurors, of placing yourself in the role of the person who got killed here, and how would you feel if you were in the position of this victim? And she's setting it up by saying, when you go home, you feel safe. That is being threatened by this cop and this fact scenario, and that's how you should make your decision. So it's creating an improper framework for which the jury can be judged. Now, what is a golden rule violation? A golden rule is asking the jury to put themselves in the position of the victim. And that is exactly what this is, because the victim is in her home. The victim was, and we all agree, the victim in this case, the person who was shot, was acting completely legally. She was in her own home, and it's a complete tragedy, and I'm very much against it. I don't want to be, but the fact is, that is not the issue. And so is saying to the jury, the home is your hearth, and this is being violated. This is so important. It's a setup for a golden rule violation. Now, maybe where in this does it occur? Where does the actual objection ripen? And that's a question, because as a prosecutor, as a defense attorney, you need to contemporaneously object. So she's very careful. Basically, she's painting a picture of this home and putting the jury into that home intentionally. And that's, you are now in the position of the victim. So this theme is really a golden rule violation, the theme of the prosecutor. So that's how she opens. And then she says, many of us, we, me and you, the jury, during the Thanksgiving holiday, we are in our own kitchen celebrating with our family. Christmas right now, many of us right now have a Christmas tree in our living area. Why do we do that? Why do we put a Christmas lights outside our house? Why do we decorate our homes? Because they're ours, right? Because they're so important. And today, that's exactly why this day is so important, because the sanctity, the safety of our homes has been compromised by what he did. Okay, this is an improper argument, and this kind of culminates that whole, this is the entire theme of the state, and it is an improper appeal to sympathy. Again, it's an improper golden rule violation. It's applying to the sympathy. We're in our homes, this cop threatens our homes, and put yourself in the position of the victim. He is threatening you. Okay, and it's also you, the jury, must find him guilty to protect the sanctity of our homes. Now, that is an appeal to conscience, or sending a message, appeal to community conscience. We need to protect our homes from this guy. And that's what the jury has to decide. That is not the issue for the jury to decide. The jury is to decide whether or not the state proves all the elements of the crime beyond a reasonable doubt and disproves the defense of justifiable use of deadly force beyond a reasonable doubt. That is the only question before this jury. It is a fact question, whether as a matter of fact, the state has proven its case beyond a reasonable doubt. That means the elements of the crime itself. None of these things go to the elements of the crime. Whether you're safe in a home or not is not an element of the crime. It does not go to justifiable use of force. It is clearly an appeal to sympathy and asking the jury to put themselves in the position of the victim, and then putting the police officer outside of that group as the person who threatens our homes as a community. So it's a sending of a message. We're part of a community and he is excluded. He's the threatener. He is the danger to our community. Now, here's where it kind of gets, again, wraps up into sort of a point. He took her away, 28-year-olds, the rest of her life at the hands of this defendant. Okay, now this is now it's called disparaging the defendant, and it's not really disparaging. It's kind of like it's within that category. I think the better way to understand that is this is saying you must find him guilty because he shot and killed her. Well, there was no question he shot and killed her, right? That is not the issue for the jury. Remember, we had to keep very clearly in our minds as defense attorneys, and a prosecutor should do this too, but as a defense attorney objecting, what is at issue at this trial? The jury is a fact finder. The state has the burden of proving its elements beyond a reasonable doubt and disproving justifiable use of force beyond a reasonable doubt. Well, the question of whether use of force was justified is the fact question for the jury, and whether the state has proven beyond a reasonable doubt that the force was not justified. So the state must disprove that. Now, what is this asking? He took her away. He took her young life away at the hands of this defendant. That is simply not sufficient. That is, find him guilty because he killed her, right? It does not go to the issue in the case, which is justifiable use of force. So this one's probably a little harder to catch. All right. And maybe it's a reach, but I think it is a legitimate objection. All right. Now here's again, so we finished that part, which was, now we've moved into another section of the closing. The Fort Worth Police Department has good officers. In fact, I've worked with some of the best officers in the state in my career. I trust them with my family. They actually do serve and protect. They don't have preconceived notions about the East Side. They don't go into certain parts of town and say some deserve to be serving protected, but not others. Only the good parts, only the parts of town that I want to go to. All right, there's multiple problems with this. All right, the first is, let's see. The first is it misstates facts that were not in evidence. What are those facts? Well, where is the testimony or any evidence about the defendant's preconceived notions? She's saying that he went into this neighborhood with preconceived notions. Where was the evidence of the Fort Worth Police Department's officers about any of this? There was no testimony from Fort Worth Police Department officers about who they are, what they are. And a lot of this goes to basically giving a personal opinion or vouching, placing approval stamp of the state on a case. So the prosecutor is telling how she worked with the best artists and she trusts them and what the Fort Worth Police Department thinks. Not only is that not in evidence, that is the prosecutor putting her own opinion into evidence that was never before the jury. Whether the Fort Worth Police Department has good officers or not, was it in evidence, is not a question in the case, is not at issue. Again, it sets up a us and them type mentality. It's all of us in the world against this one bad cop. And that there was also in here, and I don't even see it there, but I would put this whole setup about the East Side and preconceived notions is painting the defendant as this racist, that he's a racist that has preconceived notions about what is contained within the East Side. There was no evidence to that at the trial. So that's not, facts are not in evidence about any of that. Where was the evidence in this case that the officer had preconceived notions? There was none. But she's saying all the officers, they don't think that way, not in evidence. And he comes in, he thinks that way. Now you could argue, and maybe the state would argue, that this is the theory of the state's case. This is his motive, but there is no evidence of that motive. And he was responding to a call in his duty. I mean, how is that motive expressed? In what fact came out before the jury that shows that this motive exists? There was zero, right? So that's not how it works here, because our community is all of us, and it was hers too. Now, this is a misstating of the law. When you say this is not how it works here, that is a very vague statement. That is a vague statement that just, it excludes, it's putting together a straw man of the system that she's playing into. And then what she's going to fill that empty vessel of trial process that is undefined with all of these preconceptions that are not the issue in the trial, right? So that's a misstatement of the law. So saying this is not how it works here, it's arguing the law is a certain way that requires conviction. And it has something to do with protecting all the parts of our community. The proper standard, again, is the state must prove the elements of murder beyond a reasonable doubt and exclude the justifiable use of force beyond a reasonable doubt. That's the proper standard. Now, this is also a golden rule violation, improper appeal to sympathy and emotion. So find him guilty because she was one of us. You see, our community, the person that was shot here is one of us. And we hold people that hurt one of our community, us and them, accountable, right? Well, that is a improper appeal to sympathy and emotion. It's a golden rule violation because it's saying she's one of our community and you are part of her community, right? So improper appeal to community conscience. Send a message that our community is all of us. We stand together against the racist cop. Now, here's the next part. Despite what he thought when he went over to that house, it wasn't a dope deal gone bad, a robbery or shooting, high crime area. This is a 20-year-old woman who is a daughter, sister, aunt, setting to be a doctor, taking care of her nephew. Yolanda, her mom, was a good person. Zion was a good person. James Smith lives on the east side. He's a good person. The family are all good people. All right. Again, this is a disparaging of the defendant. The cop is a racist. All right, well, maybe he is. Maybe he's not. That's not relevant. It doesn't matter. You don't convict somebody. He is not guilty because he's a racist. He's not guilty because he's not a racist, right? That is not the issue in the case. We don't try people. Okay, everybody who's a racist, they're tried and they're guilty. Anybody who's not a racist, well, they're innocent. Is that the way the system works? That's not the issue in the case. The issue is the elements of the crime and disproving the justifiable use of force. Keep that in mind, right? So that's a disparagement of the defendant. Should have been objected to. Now, burden shifting. Let's go back. This is a long one, right? So how is this a burden shift? Whether people are good or bad is not the legal standard. And what that does is it operates to reduce the burden of proof on the state. So it's not quite a burden shift. What it is it's a diminishment of the burden that's required of the state, not only on the proper elements and disproof that they have to do, but it changes the target from those elements and that disproof to something other than that. And so, for example, if the standard is whether those people were good, we've proven all those people were good people. And you agree with me, they were good people. Let's put the approving stamp of the state. We all agree that those people are good people, her and her family and everybody, and kumbaya, right? All right, well, great. You've proven something that's not at issue. And the fact that that becomes the target now, that becomes the target for the state, in effect lowers the burden of proof for the state. So that is a misstatement of the burden of proof, and that is basically a burden that would be under the category of burden shift. Misstating the law. This is similar and it's related. Talking about how people on the east side are good people is arguing the law requires conviction based on factors other than the elements. And that has to do with something about protecting parts of the community. And again, I'm restating the proper standard here. It's also facts not in evidence. There was no facts and evidence about the officer's thoughts, about his preconceived notions again, about what he thought about these people, whether he thought it was a drug deal gone bad or high crime. That's all insinuating that he's got racist thoughts, right? There's no evidence of that. Where's the evidence about them being good people? Again, was that before the court? Did everybody, are we going to have what we're going to do in criminal trial now? Is that we're going to have a parade of witnesses talking about how good the person that was shot was, and a parade of witnesses about how bad the person who shot was. All right. And then we'll decide on those bases. And then the defense, of course, will do the opposite. They'll talk about how bad the person that was killed was and how great the guy that shot was. And then we'll have a popularity contest about who's the good person and who's the bad person. That is not the criminal process. That is not what trials are about. So, and to argue these things and put that before the jury that wasn't the contest in the trial, in the evidentiary phase. So it wasn't in evidence to begin with. And then to make this whole case about that is missing the point entirely of what a criminal trial should be. Now, there's also a giving personal reprieve or vouching. Prosecutor's opinion about who the good people are is irrelevant and improper. And it's also an improper appeal to sympathy and emotion. Because these were good people, you need to convict the officer. That's what the statement is. She could be the saint. That does not mean that the shooting was not justified in the totality of the circumstances. It's not the point of this trial. When you put on that badge, this is her next statement, and you put on that uniform, you say you're going to serve and protect us all. That means her too. And that's an appeal to community conscience. So restated, send a message that we are one community and that we do not tolerate cops with preconceived notions by convicting him. Isn't that what she's asking here? Is that a fair restatement? Now, like I said, some of them you may say, oh, Gosney, you're off. You're reading too much into this. Well, am I? Read this statement with that. What is the point of her making this statement in closing argument? If not to say that we're in this community together and you need to defend the community against this racist cop. Now here's her continuing. And the Fort Worth Police Department, those officers that do serve and protect us and don't have these preconceived notions, that did a thorough investigation of the case, are ashamed that they ever called someone like him a brother in blue, because it means something when you put on a badge. It means you don't go to a house with a preconceived notion because you want to have that kind of power. All right, now here's kind of wrapping this whole thing up into a big bright bow. Again, disparaging the defendant. The defendant is a police department outcast. Is that a reason to convict? Because let's look what he says here. They're ashamed they ever called somebody like him a brother in blue, condemning this outcast officer. So does that mean the use of force was justified or not justified? What does the opinion of the officers of the police department have to do with anything? That is, the jury is the fact finder. The jury is the one to find out whether it's justified or not. The opinions, we all didn't like him. He's not one of us. It's a burden shift. So the Fort Worth Police Department being ashamed is not the proper standard. And I'm restating the proper standard. One of the ways to catch these type of closing argument things is to keep that in mind about what is at trial here. What is at issue here? And that's the proper standard. And all of these things conflict because they're not relevant. They're not going to that issue. Misstating facts of evidence. Well, so where's the evidence about the thoughts of the Fort Worth Police Department? Now, here's what she says. The officers that protect us don't have those preconceived notions. They don't? Where was the evidence of that? And so it's like, so we're going to have a parade of officers talking about whether they have preconceived notions. Let's assume they all do. Does that have any impact on the justifiable use of force? Let's assume they all don't. Does that have an impact on the use of force? No, neither one is relevant to the question before the jury. And then the fact they're ashamed that they ever called somebody like him a brother in blue. Very, very bad. Oh, very much over the line, should have been objected to. And that was not in evidence. Did anybody from the Fort Worth Police Department come up and testify under oath that we are ashamed? And if they did, would that be allowed? Would the defense sit there and not object to that? That would be an opinion testimony that is improper character disparagement of the defendant. That is not proper testimony. It wouldn't come in the evidence phase. It didn't come in the evidence phase. And now she's putting that as something that should be considered by the jury in closing arguments. And it's also giving personal opinion or vouching. The Fort Worth Police Department do not have preconceived notions on entering the house because, well, believe me, because I know them. So she's putting in evidence her experience. The prosecutor saying, I know these people and they don't have preconceived notions. So that's putting the vouching stamp on the Fort Worth Police Department, who all agree with us and reject him, right? They're good. They're ashamed because they're good, and I know they're good, and he's bad because I know he's an evil racist cop who has preconceived notions. And then it's another sending the message, convict him because we must send a message about what the badge means. What the badge means is not an issue. There's a recurring theme here, would you say? It's the whole theme is improper. But if you understand the state's burden of proof, it becomes more apparent if you keep that clear in mind. All right, haven't we all met an officer that just likes being an officer a little too much? I've been pulled over by those guys before. Power hungry, tunnel vision. It's a little scary to me. Those people we don't. Now, here's the one proper and correct defense objection. So it objects to outside the record, facts not in evidence. Personal opinion, again, that was proper also, and it's irrelevant. All of those things, those were all three proper objections. And the judge sustained that. And then he says, instruct the jury to disregard. Judge instructs to disregard. So the judge is on board. He's waiting for these objections, but the defense only objects to this one. All of this up to this point should have been objected to, and it looks to be like the judge may have sustained it. At some point, this becomes a mistrial material. You don't want to say, okay, actually, I would go for, disregarding is one thing. I'd also ask the judge to admonish the prosecutor in front of the jury. You want to go, and then if it keeps going and going and going, at some point you're going to want to ask for a mistrial. So, but this is the one thing that the defense did. All right, so they got that one. So here's the next prosecutor. So after that, she comes on. Throughout the course of their entire investigation, what the police department determined, they talked to all these witnesses. They looked at all the evidence in this case. What you guys got over the last 2 weeks, that's what they have. Forensic interviews from Zion, witness interviews. They talked to folks, the autopsy report, the photographs, the body camera, frame by frame, just like what we watch. They went through all of that, and they determined it's murder. They issued an arrest warrant, and a district judge signed saying it's murder. So let's look at this. The police department determined it's murder. The police department issued an arrest warrant, and the district judge all said, so the police department and the district judge say it's murder. All right, first of all, that's a burden shift. We, the state, don't have to prove what happened to you because the police and the judge have already made that decision. You're lifting the burden from the jury and saying this stuff has already been decided. It's a mere formality. Do you want to go against the police and the judge who have already declared this to be a murder? Who are you, jury? Well, except that they're the fact finder. They're the ones that have to make those determinations. This is what they call invading the providence of the jury. This absolutely should have been objected to. This is one's very clear. Invading the providence of the jury is you, the jury, don't have to, you just defer your decision-making process. You are the fact finder, but you don't have to really find the facts. You can just agree with the judge and the police. They've already made that decision. They've looked at everything. They know what's really true here. You just follow along, right? Well, what is the role of the jury? The jury is the fact finder, not the judge and not the prosecutor. There's a reason the state has the burden of proof beyond a reasonable doubt, because this is the forum for which we determine whether it's murder or not, the jury trial. And the jury is the one that determines whether it's murder or not. Everybody who's charged and every warrant that's signed by a judge is true. So we, the jury, have no role. It's a diminishment of the role. This is a big problem. Of placing the approving stamp of the case. So restated, we, the state, only prosecute those who we know who are guilty. The judge only signs warrants on people that are already guilty. This jury trial thing is just a mere formality. See how that's a problem? The question in this case has never been, is it murder? All right, well, I've got a quibble with that term. All right, so she does go on to say the question they raised this week was, is it self-defense? All right, first of all, it should be murder is a conclusory word. That is what's at issue for the case. So for him to say the question is not whether it's murder, well, no, it is, because if the defense was justified, if the officer was justifying the use of deadly force, it was not murder. It was an accidental killing or a wrongful killing, maybe. It was a death of somebody that was justified in the totality of the circumstances. To say it's murder is now assuming, but you can excuse that to argument, all right? But she's back ending this with the fact that the judge and the police have already determined it's murder. All right, I'm just quibbling with the word murder and the fact that that's already been settled. It hasn't been settled, all right? But let's keep on moving. The question they raised, was it self-defense? Well, I think it's not. Self-defense is a little bit narrow. I think the proper term is justifiable use of deadly force. A little bit of a terminology quibble, and it is argument. And self-defense, okay, you could say he was defending himself, but really the question is whether he was justified and whether the state has disproven the justifiable use of deadly force beyond a reasonable doubt. All right, fair enough. Is it self-defense? That's her terms. What's really important about the court's charge is that this is the law that applies. We do not view it based on what he says, he, the defendant, only what he says. One okay paragraph, all right? So I'm going to give a thumbs up on this one as the only paragraph in the entire argument or in the entire closing argument that is, I think, probably not objectionable. I'm quibbling with the term murder and self-defense, but I think that this could be considered fair argument. If you were to object with those terms, you'd say, well, this is argument, counselor. So let's just say, here's the paragraph that may actually be proper. All right? Because the question is, in this case, was it self-defense? That is the question in the case, right? And she's arguing it was not self-defense. She's arguing that it was murder. And what's important is the law that applies. That's all correct. And let's view it on what he says and what the totality of the circumstance. So this is kind of, I would say, genuine argument here. So no quibbles. Here's the paragraph that's good. A person doesn't get to harm another, get up and stand and say, well, I was doing it in fear of my life, and we just let them go. We just take their word for it. All right, this is a bit of a straw man argument. First of all, it's a burden shift. And what that means is it misstates the burden of proof. So the proper standard, again, keep this in mind, the state must prove the elements beyond a reasonable doubt and exclude justifiable use of force beyond a reasonable doubt. That's what we got to keep in mind. Defendant's a witness. His credibility can be attacked. But to set up a polarity of he testifies to something and he walks versus he's not taking his word for it, that's a misstatement of law. It diminishes the burden of proof. What I mean by that is the defendant has legitimately raised the defense of self-defense. All right, that is the state's. He got up and testified that he was justified. He was in fear for his life. That's why he shot. And she's saying, well, if basically an officer gets up there and says that, then we just let him go. All right, that is not what happens. Obviously those statements need to be weighed as credible or incredible based on the totality of the circumstances. That's proper. You could impeach him maybe, or you could attack his credibility based on different credibility, maybe why he has a motive to lie. That would be proper. But she's saying that, well, if you find him not guilty, if you find his words credible, then then any officer can just murder anybody and just say it was self-defense and we let him go. All right, that is setting up a polarity that is false and in fact reduces the burden on the state because they have to disprove justifiable use of force beyond a reasonable doubt. They should instead be saying, he got up here and told you this story. Here's why that should not be believed. This is why that is an incredible. That is why we have proven justifiable, even though that justifiable use of force has been raised. Here's why that he should not be believed. They need to disprove their legitimate raising of that defense. All right. And this doesn't do that. This instead just sets up this polarity of, well, if we let him get away with this, if they can just get up and mouth these words and they walk, and that's not the standard. No, but the state does have a burden of proof to disprove the justifiable use of force. And by setting up this polarity, she is reducing her burden on herself as the state. All right, enough of that. Commenting on the defendant's rights. The defendant can't get up on the stand and testify on his own behalf. Okay, a person has an absolute constitutional right to get up on the stand to defend themselves, right? So she says a person doesn't get to harm another and get up on the stand and say, well, yes, they do. I sure as hell hope we do have that right. We have a right to get on the stand and defend ourselves from the state wanting to put us in prison for the rest of our lives. I would hope. It's called a jury trial. You have a right to a jury trial. You have a right to put the state to their proof, and you have a right to get on the stand and say whatever the hell you want to say. It's because your life's on the line. But she says a person doesn't get to harm another and get up on the stand and say, and then we let him go. Say, I was doing it for my life and then let him go. That is a disparagement of the right to testify and should have been objected to. Imagine that scenario. Imagine what would happen if that were the law. Then not one single person would ever be held responsible and accountable for what they do. If they can just say it is, so it is. That's not the way this works. Oh boy, see, this just culminates, this distills all of those improper views into one tight little bunch, right? Maybe this is going to repeat myself here, but the first thing is disparaging the defense theory. The defense must be disproven by the state beyond a reasonable doubt. So she is setting up a straw man saying, this is not how it works. It reminds me of Obama would always say, that's not who we are, right? So he'd set up like all these racist people, burning down churches. That's not who we are. Well, who's saying they want to burn down, be a racist and burn down churches, right? I mean, not me, not my community, right? But it sets up the straw man so that you can then oppose it. Well, she's setting up the fact that all that's required for the defense to be sustained is he get up there and mouth some words. And that's not the way this works. Well, no, that's not the way it works. But the way she's saying, she's putting in the opposite, saying, okay, if this false straw man that I'm going to create would bring through these parade of horribles of all these people getting away with murder. So that can't be true. Well, that's not what's happening. That's not the standard. That's not the burden. So it's a disparagement of the lawful use of deadly force and misstates the law. It's also a burden shift. It's a burden shift in that it lowers the burden to disprove justifiable use of force. Holding someone accountable is not the standard. So she says, not one single person would ever be held responsible and accountable. Well, holding somebody accountable and responsible is not the standard. It's proof beyond a reasonable doubt that they're guilty of the elements, not holding them accountable, holding them responsible. Commenting on the defendant's rights, that's not how this works. Implies that defendant testifying raising defense is somehow wrong. Misstating the law. Okay, so again, we talked about that, and it's a repeat here. It's a follow-on. Appeals to conscience and sending a message. So send a message in our community that officers can't harm people and get away with it. In our community, we hold our officers responsible and accountable. All right, that's sending a message to the community. That is a community conscience type thing. It is not the elements of this crime. If it is a crime, which the state has to prove, right? All right, what is the law? And what you guys have in front of you is what has to be reasonable belief and immediately necessary. All right, fair enough. So how do we define what's reasonable? Right, that's also in your core charge. It's a belief that would be held by an ordinary prudent person, okay? All of you guys with what he did out there, was that reasonable? Was that immediately necessary? Okay. Here's the one very important part. And I can tell you right now, the defense gets up here and talks, they don't want you to focus on this. This is the law. This is what we've charged. This is what we're bound by. Unlawful deadly force, unlawful force. All right. So what are we doing here? It's disparaging the defense attorney or defense theory. The defense attorney doesn't want you to focus on the law. He says, I can tell you right now, when they get up here and talk, they don't want you to focus on that. This is the law. So the defense doesn't want you to follow the law. Really? Okay, that's a disparagement of the defense or the defense theory or the defense attorney. It's also misstating the law. And this was the critical factor, and we talked about it. And Andrew, and I'll summarize kind of the core misstatement of law. Maybe I'll do that in a future slide, but there's also a misunderstanding of the law of self-defense and justifiable use of force as it applies to this case that was adopted by the defense team and really gave this client no chance. And we'll talk about that in a second. The only way this conduct is justified by this defendant is if it's reasonable to all of you that what he did immediately necessary. And the most important is her, meaning Tatiana's unlawful force towards them or unlawful deadly force. Okay, now here is the critical misstatement of law that just destroys the defense and is a misreading of the statute. And Andrew goes into this very deeply, but I will talk about it a little bit. The first thing is the way that the state and the defense were reading this statute. They were saying that if Tatiana, the victim in this case, the person that was killed, she had to be acting unlawfully in order for the officer's use of force to be justified. All right, that is false. That is not the law. Now, I'm not a Texas lawyer. Maybe I should qualify to say all this is Florida lawyer stuff, but it's also my understanding this is the law in Texas. She could be using force. Both parties could be lawfully in the use of force. The problem is it's the perception of the officer, given the totality of the circumstances, whether he was being threatened by what he thought was unlawful use of force. Now, why is that important? Because we only punish in criminal law guilty minds, mens rea and actus reus. That means guilty mind and an act that follows that guilty mind. If somebody is under the reasonable belief that they are about to be killed with deadly force, if they're being threatened with deadly force and they have a perception that they are being threatened, then they are justified in their own minds that they are defending their own lives with using deadly force. All right, now they may be mistaken. And in this case, the guy was clearly mistaken. He was clearly mistaken that that person was threatening him with unlawful force. Now, maybe she was threatening him. That could have been. In that she would have been justified and he would have been justified in this scenario. And it's a bad fact situation for that reason. But the fact is that she doesn't have to be acting unlawfully in order for him to be using justifiably using deadly force. What's required is for his mens rea to be culpable, for him to be acting recklessly. All right, because we don't punish innocent people. We don't punish people whose minds are innocent. We don't punish somebody because they made a mistake. You get in a car accident and you made a mistake. Well, but you didn't intend to cause the car accident, but you killed somebody. Well, we don't hold you criminally responsible because you made a mistake and accidentally killed somebody. That's not what the criminal law is for. The criminal law is to punish guilty mind, to give the mens rea element. All right. So to make the question whether or not Tatiana was using unlawful deadly force is not the question. And by making that an element, then that basically there is no question that she was acting lawfully. There was no. Now the defense tried to counter this by saying anytime you point a gun at a cop, it's unlawful. Right. And they did that because they thought that was an element that they needed to attack. But I'm saying that's not a proper reading of the law. And this misstatement of the law is deadly, All right. But the prosecutor's basically just echoing this reading of the law here. So we've talked about that. I think there's going to be a lot of misstatements of law along these lines, and I'm not going to repeat myself. Okay. And here she says, the only way he's justified if the actor reasonably believes deadly force is immediately necessary to protect the actor, yes. The actor being the defendant, yes. Against the other person, yes. And Tatiana's use of unlawful deadly force. Here's the mistake. So think about that for a minute. What's been unlawful about what Tatiana did? That's exactly the wrong. See, there's where the misstatement comes. What's unlawful? So if the jury finds, oh, well, she wasn't acting unlawfully, then his use of force was not justified. That's the leap of improper law. Have we not seen one shred of evidence that anything that Tatiana did was unlawful? In fact, we heard quite the opposite. All right, well, that's a misstating of the law. That's also, I would say, a burden shift because but see, reading the law, it's a misstatement of law. So it may be also a burden shift because they're saying that the defense needs to produce evidence. The defense needs to produce evidence that she was acting unlawfully, right? Well, they weren't able to produce it because she wasn't acting unlawfully. And I'm not saying the guy's not going to be held accountable or responsible because there's going to be a civil suit. There'll be a big civil judgment. There'll be a big money payout in which the people will be made whole with money. So the question is whether the officer goes to prison for 10 years, right? Holding him accountable for criminal mens rea. So unlawful, we've already got that. You can be in your own home, owning a weapon, owning a gun, and you can protect yourself. Now, here's again, putting the jury in the feet of the victim. That's one of the most fundamental rights. That's the reason we all feel so safe. Atatiana Jefferson didn't commit any criminal act by walking up the window with her gun. Again, here's the misstatement of law. Thinking if someone's outside. It's what many of us would do. So we're in the same position as her. If we were in our house in the middle of the night in the back bedroom and we heard somebody outside, that's what you would expect for us to try to protect ourselves. And in this case, Zion, that little kid, as well. So there's not been any evidence to support anything she did was unlawful. And you've got to have that. That's what the law says. All right. That's the misstatement of the law. I mean, that is right between the eyes misstatement of law, unobjected to. And I think the defense bought into that. And I would say also, and I didn't even put it in here, again, missing one, there's also a bit of a golden rule violation here because she's putting us, this is what you would do. You are in the same position as this decedent. And you wouldn't do anything wrong, and yet cops are going to come and shoot you through your window. How would you feel if, right? So, but it's not blatantly obvious. The big point here is it's a misstatement of law. And if you think about it, it makes sense in this case because she was in her own home. If we can't feel safe there, where in the world are we going to feel safe? All right, here's our golden rule violation, appeal to sympathy and emotion. How would you feel if you were in your own home feeling unsafe? How would you feel? Golden rule. That's not a proper argument to the jury. How would you feel if you were in the position of the victim? All right. This defendant, when he put on his uniform, had a tremendous amount of power. She loves the power, right? A tremendous amount of power. And when you talk about what's reasonable, when I talked earlier about the Fort Worth Police Department, when they went through and they did their thorough investigation of what happened, they considered all of what you guys have seen as well as the general orders. So it's a burden shift. It's a reprise of the earlier error where we, the state, do not have to prove what happened to you, the jury, because the police have already made that decision. Jury is the fact finder, not the police at a jury trial. All right. I put that in here too. Now she's reprising it like this is a little bit of credibility enhancement that I'm putting this in these instructions in the law and you guys can ask for it, right? It's a buffing of the improper statements by saying, oh, it's all in the law. It's all lawful. It's the law that you must follow. You must find him guilty according to law, which would be proper if it was argued properly. But it's improper when you're asking the people to find them guilty on improper grounds, right? If you guys want to go through, you can ask for the general orders. You can say exactly what they say, see exactly what they say. It's not about what I say or they say. It's about the kind of any kind of spin the defendant wants to put on it when he took this stand. It's exactly what's written down. All right, here's a disparaging of the defense theory. General orders are not the law and justifiable use of force. Defendant putting a spin on those general orders disparages a correct fact question in this case, and that is whether the state disproved justifiable use of deadly force and no other question. So the general orders question, note that she really doesn't get into the general orders, because if he is following process and procedure, that is a cloak. That is justification. She should have been reading the general orders and saying how his conduct did not follow the general orders, but there's no specifics here. It's a general accusation that he's not following it, right? And that everybody agrees he's not following it, and that's why we're here. Instead, she should have read the general orders and said specifically what he did specifically that was outside that. Now, that doesn't mean that the force wasn't justified, but it is a measure, it's a standard by which they can judge his reasonableness, all right? It's a tough call. It's a tough call. The state's having a high burden of proof. I'm asking a lot from the state, as we should, because they're seeking to put him away for life. He ends up getting 10 years, but they're wanting to put him away for life. The standard on the state should be very high, and that is they need to prove their case and disprove the defense beyond a reasonable doubt. So for him to rely on these, just kind of be sloppy and to slop it out, is a lowering of the burden. We're just going to talk generally. He's a bad guy. They're racist cops. The community wants you to convict. Cops are all against him. Let's just all put him away so we'll all feel safe. All improper. All improper. It's a betrayal of what a prosecutor should do to follow the law. It's the very thing the defense said in an opening statement. They follow all the steps and procedures as you're supposed to. An open structure is a silent alarm, and they did everything right. And that's what the police defensor got up here and said. He wouldn't agree with anything that we asked him. So what? But that's the one thing he said. Everything he did was right. Well, that is not the case. Very first thing, officer received the call. That's him, right? He's the sheet officer. He's the main officer. He calls the shots. Step 2, all the main exit ways should be guarded so as to prevent the escape of any defender. We start there and we fail, right? And that was amongst the many, many, many things he did wrong. So the one officer that responds to a possible burglary in the middle of the night in this community goes there and he says he's supposed to secure all the main exit ways should be guarded. So the one guy should guard all the main exit ways. Okay, and so that is this is what she's supposedly doing with the general order, saying he didn't follow because he failed on this one thing, which is humanly impossible for that one officer to do. Therefore, he's guilty. That has nothing to do with the point at which he fired the shot. Is that the totality of the circumstances? Is basically if an officer comes there and cannot follow these orders, which no officer, one officer showing up could never do this. In no case could that ever happen. So no officer could ever comply with his general orders. And therefore, because of that, they can never use justifiable use of force when they're threatened by the firearm. Is that the law? But she's saying he failed that initial test. Therefore, boom, no justifiable use of force, deadly force, period. That's it. Game over. Really? That's the law? That's her disproof of the justifiable use of force? And then she says, oh, and just everything else. He didn't follow. Everything we said was wrong. So all the second guessing that you could do in any case was wrong. All right. Burden shift, whether the officer did everything right or wrong is irrelevant whether the state disproved justifiable use of deadly force. Misstates of the law, focusing on alleged errors of police officer and whether such errors did or did not occur is not the law relating to justifiable use of force. It's not an element where they need to prove or disprove. It may be evidence such a force was justified. It's not the stopping point for proof. It must be linked to the state's burden of proof, or it's a lowering of the state's burden and an improper statement of law. Does that make sense? Okay, so what we're saying is she's setting up as her burden of proof that the officer didn't follow the general orders to the T, and this one thing about guarding the exitways. And because he didn't do that, then he's guilty. Okay, so now you've in effect lowered the burden of proof, which we've talked about the standard where you kept in your head, to this other thing. She's created a straw man legal, a legal proof that we have to prove he didn't follow these policies. And we did that, therefore he's guilty. You see? So now I've in effect lowered my burden of proof to this other thing, which it doesn't go to the elements of the crime or disproving the justifiable use of force. All right. Because it wasn't important to him to serve and protect that day. It was important to him to get there and get in the action. Power. It can corrupt certain people. Certain people don't need to wear a badge. Certain people do not need to have the power and the control if they do not respect the accountability in this case and the grave effect that it had. All right, well, this is a burden shift. Whether the defendant was motivated by power, getting in the action, or protecting and serving is irrelevant to the question before the court, and making that the issue lowers the burden of proof on the state. It's also irrelevant whether the defendant should not have the power and did not respect accountability. To suggest that this is an issue in the case is a misdirection not aimed at the elements and lowers the burden of proof on the elements of the issue. And accountability is not the issue. She is in effect, and let me see if I did a comment on, yeah, it's a comment on the burden of the defendant's rights also. So he's saying that by asking for the jury trial, by putting the state to its burden, by making the state prove the elements beyond a reasonable doubt and disprove is justifiable, that he was not accepting accountability. So he's exercising the right he's making us prove these things. The state doesn't have to prove their case. He has to accept accountability. You see how that shifts the burden over to the defendant? The deferred defendant should be accepting responsibility, but he's not. He's asking for us to do our job. He's asking for a jury trial. How dare he do such a thing? You see, it's a burden shift. It's a shift over to the defense that they should plead. They should accept responsibility for this crime by pleading guilty to these elements and not asking us to do our jobs. All right, misstating facts not in evidence. Was there any testimony about defendant being motivated by power or getting into the action? Where was that at? Where was that testimony? Now, you could say, well, this was his motive. This is why he did it. He's motivated by power. But I would suggest that a lot of this is projection. This prosecutor is really, she gets off on power. She is really into the power. And it seems that's a theme that runs through this. Well, I would suggest that may be a projection from the prosecutor's head onto this defendant. And she loves the jury's got all this power. And wouldn't it be great to have the power to fix the world? Well, if I was God King, I'd fix the world's power. I'd use that power to fix the world and no evil would exist. Well, that's not the world we live in. That's not who we are, right? This jury does not have the power to make the world utopia. This utopian vision that she has of the world will be perfect if you find him guilty kind of reminds me, what was the name of the movie in Idaho? The kid that was Napoleon Dynamite. Vote for me and all your dreams will come true. Vote for Pedro, right? No, that isn't not what happens here. And we'll echo that in a second. You guys have that ability today. Here's this error. Over 3.5 years, we've waited. They've waited. She points to the people in the courtroom, very improper. They've waited this day. Everybody in this room, all the rooms outside this room, everybody in the community has waited for today. Completely improper. Appeal to sympathy and emotion. The decedent's family have waited for a trial is irrelevant to the state's burden of proof. Because they've patiently waited, you should find him guilty? Really? Sending a message. The community is waiting for you to send a message and wants you to vote guilty. Everybody out there, everybody's waiting for you to vote guilty. Right? Everybody's against him. Are you on our side or are you on his side? I mean, does not go to what the law should be. This is not what a jury trial should be. Because today you can say you can't create the danger and then claim self-defense. Now, this one's really, really bad. Because today, you, the jury, say as a community voice that you, officer, can't create a danger and then claim self-defense. Really? I mean, this is wrong on so many levels. Let's go through it. Disparaging the defense attorney. It's a minimization of the justifiable use of force. Decide an issue that's not the law. You can say you can't create the danger and then claim self-defense. You can't. So that's saying that anytime I would create a dangerous situation, I can never claim self-defense. What if I go into a dangerous situation and like I'm outside a club somewhere and I start getting into, I come up to somebody, I don't like the way you look, and I get into an argument with him and I'm just mouthing off, right? I'm creating a dangerous situation. That guy pulls out a gun and shoots me dead. Or pulls out a gun, he pulls out a knife and starts to stab me, and I pull out a gun and shoot him dead. Well, the other person escalated to deadly use of force, and I was justified in using deadly force. I'm just getting in a verbal argument. Well, I created a danger by approaching that guy, right? So I can't claim self-defense in that situation, right? You see that this is an error. This is a misstatement of law. The fact is that you can go in and create a danger and then create self-defense given certain circumstances. That is a misstatement of the law. Burden shift. Burden on the state is here we go. Disprove justifiable use of force. The statement here seems to indicate that the defense has the burden of proving justification. Can't create that, right? We talked about 4. Appeals to community conscience. Send a message. Send a message that you can't create the danger and then claim self-defense. We don't believe that. That's not who we are, right? Send a message. The jury's job is not to send that message. Today, you can say you can't create it. So you, the jury, are going to be the lawgivers. You're going to create the law. The law is passed by the legislature. The jury's job is to be a fact finder. This is almost a reverse jury nullification. This is asking the jury to decide on a question of law, to vote for something that's not before them, make the law up, and find the guy guilty because this is the way the law should be, not what it is. This is just such an improper statement. Okay, we want to feel safe in our own home. Today, you guys' decision in this case, finding guilty, says, I'm holding you responsible. I'm holding you accountable. I'm following the law. Again, terrible. Holding someone accountable is not the role of the jury. Holding someone accountable is not the standard. I mean, how many times do we have to say this? There's, again, the risk statement. Following the law is not holding people accountable or holding them responsible. See, here's the thing. He could be found not guilty and still be accountable and responsible. He could be found guilty and not be accountable or responsible. These are independent questions. Whether somebody's accountable or responsible is an independent question of whether they're guilty beyond a reasonable doubt of the elements of the crime. Does that make sense? And so then she says, following the law is holding them accountable and holding them responsible. That's not following the law. That's not the law. Nowhere in these jury instructions it says, you, the jury, found him accountable. You, the jury, found him responsible. She's adding these words that are, in fact, not part of her proof. because she wants that to be the question. And that's a lowering of the burden. It's also a golden rules violation. We want to feel safe in our home. That's what she says. We want to feel safe in our home. It's a golden rule violation. It asks the jurors to put themselves in the position of the defendant. We, the jury, we, the community, want to feel safe, and you've got to feel guilty to make us all feel safe. That's a community conscience appeal. Whether you feel safe in your home has no impact on whether he's guilty or not guilty beyond a reasonable doubt. That's not the jury's function. That is not the jury trial function. That's not the function of a courtroom or the criminal justice system. The function is to hold the person's guilty mens rea accountable and disprove justifiable use of force. Back in the same thing. And this is where so miss the boat on this. Appeals to community conscience. We hold people accountable. We hold people responsible. All right. It asks them to be the jury to be a community representative rather than a fact finder. And here's the power theme. With the power you all have today, which is more power today to change lives, to hold people accountable than most people have in a lifetime. This reminds me of, remember the Spider-Man, the power of the sun in the palm of my hand. It's like there's almost an ecstasy behind worshiping this power. It's amazing. This power theme is strange, but the prosecutors obviously getting off on this power theme. So with the power you all have today, you, the jury, more power to change lives. Really? There's only one life at issue here. Hold people accountable. People generally, it's hold the defendant accountable or guilty. Most people have in their lifetime. What a wonderful thing. Power you guys have today is to hold him responsible, to tell them it wasn't in vain. Oh, horrible. No objection. It's to say she matters. They matter. East Side matters. We protect everyone and the law agrees. This is just terrible. Burden shift. All right. Changing lives is not the jury's role. Holding someone accountable is not the role of the jury. Holding someone accountable is not the standard or the role of the jury. The jury is the fact finder. And then here I'm going to restate it, right? It's misstatement of the law. Law is not holding people accountable, holding people responsible. Finding that she matters, they matter, and the East Side matters is not a fact question for the jury. If they find him not guilty, that doesn't mean that the girl that died doesn't matter. It doesn't mean that the East Side doesn't matter. That is a straw man. It improperly places before the jury something that's not an issue in the case. The defense is not trying to show that her dying was not in vain or was in vain or whatever the thing is. The defense is not saying that that girl doesn't matter. The defense is not saying that the East Side doesn't matter or the family doesn't matter. That is not before the jury. Okay? But she's saying that by holding him guilty, the law wants the jury to find on this issue. The law is saying that by finding him guilty, that validates her life and all the I guess the East Side is the black community valid. That is not an issue at this case. It's a golden rule violation, improper appeal to sympathy. Telling family members of the deceased that their loved one did not die in vain is an improper appeal to sympathy and emotion. Finding a man guilty of murder or to make someone feel that their loved one did not die in vain is an improper emotional appeal. Make them feel better by holding him guilty. Gee, is that what if you were charged? I'll make a golden rule argument back to you. What if you were charged with a crime, a justifiable use of force crime, and everybody wanted your head on a pike, and they say the person you killed was a good person, and you got to make these people feel better by holding you guilty? Is that the kind of trial that you would like to have? You see, this is a golden rule violation I'm giving to you, but I'm not in trial. But allowing this, see, that is not what the court system should be doing. Improper appeals. Finally, phew, this has got everything in it. Sending a message. We hold people accountable. We hold people responsible. This is not the question. It's asking the jury to stand as a community representative rather than fact finder, right? And it's a reprise of the improper arguments about the East Side, some kind of community validation demanding a guilty verdict. Sending a message, community, we protect everyone. Improper appeal to community conscience. Asking the jury to send a message, not the role. And of course, she punctuates that at the end with, the law agrees with me, and this is allowed. This is what the law is to do, is to validate people, to make people feel good about themselves by putting him away and crucifying this guy, right? Because he's a racist cop. I don't know that he is or isn't, and it's not the point. And the validation, finding him guilty, is not going to validate anybody. All right. Everything in this case, all the evidence in this case, is demanding a guilty verdict. That's exactly what we are asking from all of you today. We know what he does with power. What are you guys going to do? There's the power theme. You find him guilty. All right. Well, again, sending a message, use their power to right all the cosmic wrongs in the universe. So sad. Here's the point. This jury trial outcome is not going to fix the wrongs of the world. The more you've got more power to correct the world's wrongs than anything that's ever been created in the universe. The world is not perfect. The world is not perfect. No court, no jury trial will ever make the world perfect. Any verdict, you're not going to right the cosmic wrongs. The quest for cosmic justice is not resolved in a courtroom. That is not its power. So let's just pass a law that says everything is good and wonderful and all evil is banished to hell forever. That's not, we don't have that power. We're humans, we're mortals. That power does not reside in any one jury. And this idea that this is what's going on in this courtroom is just so bad. I hope, and you may quibble with me on objections here and there, and that's fine. This is simply my opinion. I'm a Florida lawyer. It's not my case. It's out of my jurisdiction, all right? I have a method for analyzing improper closing arguments that I want defense attorneys, and I hope that this teaching tool will be good for prosecutors and judges and defense attorneys so that when they encounter these things, they'll be prepared, because we need to make our system better by making our arguments fair and making our process better, raising the standard for our prosecutors, raising our standards for our defense attorneys in our courtrooms, expecting more, expecting proper arguments, and expecting the right questions to be answered. After this case, I don't know what the jury answered when they found him guilty. What did they answer? I don't know. Because if they listened to this closing, they would be making decisions on things that were not before them. And this guy, if it was done right, he may have been found guilty anyway. If it was done wrong, what are they answering? I mean, this is why it's important. Our process must be respected, and the process was not respected in this case. All right. Hope that you enjoyed that little presentation. With that.
Well, I certainly hope all of you enjoyed Steve's video and legal analysis and insight as much as I did. Remember, you can get Steve's excellent book, Ideas and Answers in the Law, at only one place, crimelaw.net. And I encourage you to do that. It's a wonderful book. And don't forget also, Steve is the provost of our very own American law courses, where we teach traditional American law in the traditional American way at a fraction of the time and cost of law school and without the political toxicity of today's law schools. Save 50% on those opportunities. Courses on criminal law, property, evidence, constitutional law, criminal justice, and more. 50% off during the current pre-registration period for the spring semester if you register before the end of the year. And you can learn more about that at AmericanLawCourses.com. All right, folks, until next time, I remain attorney Andrew Branca for the Law of Self-Defense. Stay safe.